India and United States free trade agreement, which is currently being negotiated, and the implications that it may have on access to medicines. Now, before I invite our esteemed speakers, just a little context into what we're trying to discuss here today. So as far as rulemaking in international trade is concerned, a major focus is on liberalizing trade. And when I say liberalizing trade, we're essentially trying to reduce different kinds of barriers, which may be tariff or non-tariff related barriers, including custom duties, different kinds of quotas, licensing rules, etc. In order to reduce these barriers, countries have for a very long time entered into different kinds of arrangements, free trade, preferential, etc. However, post the Second World War, a lot of emphasis in international trade rulemaking shifted to multilateral rulemaking, primarily because a number of these preferential arrangements involving two or more members were said to be very discriminatory. That's when we see the beginning of institutions like GATT and finally its successor, World Trade Organization. Now, World Trade Organization is a very important organization currently with 164 members. And it has comprehensive agreements involving different set of agreements which try and reduce barriers in case of goods and even services now. What it also has is, it has also a comprehensive agreement on intellectual property. Now, if you want to be a WTO member, all these rules are binding on you, which includes this agreement on intellectual property, also referred to as trade-related aspects of intellectual property, right? Known as TRIPS. So you are bound to follow all of these agreements. However, WTO is also based on the principle of special and differential treatment, which does provide certain safeguards for its developing and least developed country members. So even in case of TRIPS, we do see a number of flexibilities which are available to its members. What WTO also does is it allows its members to enter into what we know as free trade, regional trade, or preferential trade agreements involving two or more WTO members, which is why these free trade agreements have continued to exist parallelly with the multilateral rulemaking in international trade. However, what happens in these, in case of countries who want to enter into these kind of free trade agreements, mostly they enter into it for enhanced trade liberalization. But many of these free trade agreements can go, the discipline in these free trade agreements can go beyond what's in the WTO agreements. In fact, can go far beyond that, as we've seen in case of many of the free trade agreements having intellectual property chapters. Particularly in the context of United States, there are a number of FTAs that US has entered into with what we know as TRIPS plus provisions, which go beyond the WTO rules on intellectual property, which is mandatory for its members. These are mostly, which we'll discuss in the session on data exclusivity or patent term extension in case there is a delay in the grant of patent or even patent linkage, etc. That is why, because US is negotiating this deal with India, concerns regarding these TRIPS plus provisions, which have significant bearing, and if I may, a negative impact on access to medicine, this discussion becomes important. In fact, India is currently negotiating a number of, entering into or negotiating a number of these deals. Because of the current challenges in the world trade system, these negotiations seem inevitable, and consequently, this conversation important in terms of what lies ahead for India. With this, I would introduce our first speaker for the day, Professor Abhijit Das. Professor Das is a renowned name for all those who follow international trade and even otherwise. He's a leading trade expert in India who's led India and represented it in several international and free trade negotiations. He's also a prolific writer, having written extensively on various dimensions of international trade. And in fact, his work has shaped debates in many of these areas. In fact, very recently, he wrote a book on strategies in GATT and WTO negotiations. There's a lot more that I could say, but I think it's best that we invite Professor Das to deliver his talk. Over to you, Professor Das, and you would have around 10 to 15 minutes.
Thank you, Priya, for a very, very generous introduction and also laying the landscape of our discussion today. Thanks to the, am I audible?
You are audible. And I request everyone to please keep yourselves muted. In case you have questions, you can please type it in the chat box and we can take it towards the end, or you can ask it yourself. And please...
You can go ahead, Abhijit.
Right. Okay. So thanks to the organizers for providing me this platform. A disclaimer is relevant right up front. I have no legal expertise. I'm not a lawyer. So with those disclaimers, let me mention that, Priya, you have very correctly situated the current negotiating environment in the context of the provisions that are contained in the TRIPS agreement. Let's recall that during the GATT days, issues related to intellectual property rights were really dealt with at WIPO. But WIPO did not have an effective dispute resolution mechanism. So the big pharma in US, plus in Japan, plus in Switzerland and European Union, they came together and ensured that when the negotiations in 1986 were initiated, it had a very important mandate on IPR negotiations. Of course, what that mandate implied became a highly contentious issue. And India, Brazil, Thailand, their stand was that the mandate did not include negotiating standards of IP protection. However, from April 1989 onwards, India was compelled to change its stand, and it started negotiating even the standards of IPR protection. And eventually we had the TRIPS agreement, which sets the minimum standards of IP protection. Of course, countries have the flexibility to go even beyond those minimum standards of IP protection. And this is what is sought to be attempted by European Union, by Japan, by United States through the free trade agreements. Their objective is to make the IP protection more stringent, number one. Number two, shift the burden of implementation from the shoulders of the IP right holders onto the governments. Another objective is, can the right of patent holders be expanded in multiple ways? Priya has already mentioned some of those possibilities, and an important element in expanding the flexibility is around evergreening of patents. Now, here an important point to be borne in mind is that under the TRIPS agreement, the three requirements have been mentioned, but how these three requirements have to be assessed, countries have the flexibility while deciding whether an application should be granted a patent or not. And this is very clearly captured in Section 3D of our Patents Act, which prevents evergreening of patents. The Western world hates Section 3D. They are trying all possible tools to make sure that through the free trade agreements, India is compelled to make changes in Section 3D so that even for very small or even non-existent improvements in a product, even if does not result in enhancing therapeutic efficacy, a second period of patent protection is granted. So that is one of the objectives. Other objectives are very clear in terms of, let us say, having a mandatory period of data exclusivity whereby the data of the originator will not be shared with the data of the generic producer when he seeks a marketing approval, or extending the period of patent protection beyond 20 years if there was a delay on part of the government in granting the applicant a patent. So there are multiple TRIPS plus provisions which we are seeing in free trade agreements, and which clearly is also being sought by European Union. If you look at their negotiating proposal made to India as part of the India-EU free trade agreement, then it consists of many TRIPS plus provisions. The government hopefully has been standing firm. Now an important point needs to be recognized over here. Whatever concessions we give in the TRIPS area in one agreement, if it contains the regulatory aspect of IPRs, then concession given to one country effectively becomes concession to the rest of the world. And here is where the real worry is. If you look at one of the agreements which India has signed in the recent past is with the FTA countries, Norway, Switzerland, Liechtenstein, Luxembourg, and one more country, Iceland. So in this agreement, we did adopt some TRIPS plus provisions, which may appear very innocuous. Now, my difficulty is if in the agreement with European Union, we accept additional TRIPS plus provisions, then what we have agreed with the FTA, what we will be agreeing with European Union, and if we agree to something else in the VTA negotiation with US, we might end up agreeing to a whole host of TRIPS plus provisions, which would dramatically change the landscape for our generics to their disadvantage. So the point to be remembered here is, while concession in one agreement may not appear very far-reaching, may not appear very comprehensive, it is still a concession. And on top of that, you add concession given in subsequent agreements. Within a couple of years, we may have considered not just a few yards, we may have considered the entire territory. So that is something we should remember. And in particular, when we are negotiating with US has a very strong big pharma lobby with tremendous clout. And they will really pull out all stops. They will persuade the US government to demand TRIPS plus provisions from India. And related to that is a slightly different issue, not linked with IP, but linked with the pharmaceutical industry. It is the stated objective of the US government that it does not want to import generic pharmaceuticals from India. If you look at White House document of 2021, it's really on resilient supply chains, etc. There's a very clear articulation that US is overwhelmingly dependent on India and China for generics. It wants to reduce this dependence, and hence it wants to source generics from other countries. This can have substantial adverse impact on our generic producers. So overall, the FTA landscape, as far as IPR goes, is gradually tilting against the Indians stated positions, let's say a decade earlier, we are moving into an environment where the government will have to fight an uphill battle. It might end up conceding something in one FTA, additional concessions in other FTAs, and we will really have to be cautious. The civil society has played a huge role in making sure that the government stands firm, and that important role gets magnified in the context of our ongoing VTA negotiations. I'm going to stop over here, Priya, and then I'll be very happy to respond to questions later. Thank you once again, ladies and gentlemen, for your very kind attention.
Thank you so much, sir. That was very, very informative. Just one little thing that I was just thinking. So, with the coming of Trump and the kind of attitude that he'd shown towards World Trade Organization, what role do you see World Trade Organization playing in, and do you think FTAs have become inevitable now? And do we sort of see that as the rule, as a dominant form of rulemaking in international trade? If you can maybe say something on this.
Sorry, I was muted. Very quickly to respond to your question. When it comes to IP issues, the developed countries recognize that negotiating IP issues at a WTO will be very difficult. So they've adopted the strategy of forum shifting. They will negotiate stringent TRIPS plus conditions in FTAs with the hope that someday many of these will get transplanted into the WTO. So that will involve multiple forum shifting from WTO go to FTA, and then from FTAs come back to WTO. And one last point over here, while Trump was going on rampant and it continues to create turbulence all around, and he has junked the WTO, but there was some spokesperson of Trump said that the only value in WTO which they find is in the TRIPS agreement. That should raise our hackles.
That is very well said, sir. Thank you so much for the lecture. And I think now we can move ahead. We have our next speaker, Roshan John Joseph, who is not just a legal expert, but he also specializes particularly in intellectual property and access to medicines. And he currently is serving as regional advisor at MSF, and he's played a key role in MSF's access campaign and contributed to policy development, government engagement, and advocacy strategies to address IP-related barriers, particularly in relation to access to medicines. Roshan would be talking about free trade agreements, particularly the India-US free trade agreement, in terms of the kind of relationship and the kind of conflicts that India and US have had over years, but seen in terms of the Special 301 processes and continued US pressure on India, and also in terms of the TRIPS Plus provisions, which is a common feature of the FTAs that US has already entered into. I invite you, Roshan, to deliver your talk.
Thanks a lot, Priya. Good evening, everyone. I hope I'm audible, and thank you very much to the working group for inviting me to this timely webinar and giving me the opportunity to speak today. As Priya said, I'll be focusing my presentation today on TRIPS plus intellectual property provisions in free trade agreements, and specifically what could come under the US-India negotiations and its implications on India's generic industries and broadly on access to medicines. This discussion is important, I feel, not just for India, but for people across the developing countries who depend on India's generic industries. Now, as we'll see, there are significant risks that a potential FTA with the United States could bring in, and as it could lock India into harmful intellectual property commitments with real consequences for access to affordable medicines. Gagya, would you be able to please post the slides, please? Yeah, please. Yeah. Thanks. Uh, India has a very low, as you may already know, that has for a very long time played a leading role as the pharmacy of the developing world, particularly due to its intellectual property laws that have kind of struck a balance between encouraging innovations, while at the same time allowing generic competition that saves millions of lives across the globe. Now, it's particularly its patent laws and regulatory choices that it has enabled this timely production of affordable and quality assured generic medicines that serve millions of people globally, and including treatment providers like my organization, MSF. Now, but a US-India FTA could challenge this by introducing TRIPS plus intellectual property provisions, which are rules that go beyond what is required under international law, which was already discussed by Professor Das and Priya, that it's called the TRIPS agreement. Now, these rules or the harmful IP provisions, when introduced through free trade agreements, could block or uh, delay access to generic medicines, undermining public health both in India and many, many developing countries. Next slide, please. Thanks. Now, we know from experience that generic competition drives down prices, and this graph actually captures one of the most significant stories in access to medicines. That the price of the HIV drug of the triple combination therapy dropped from over $10,000 per patient per year to under $150 by 2006, thanks to Indian generics. And this, you will see that it's the Cipla was the first one to bring the price to under $150, which is almost a dollar a pill. Now, this is the direct result of how India incorporated the requirements of the TRIPS agreement into its patent laws, which allowed timely entry of generics. And it's precisely this generic competition from India that TRIPS plus provisions in FTAs tend to threaten. Next slide, please. Now, if we look at the broader playbook of the United States when it comes to IP, Professor Abhijit has already touched upon it. It's more than 30 years ago, the US, and along with other developed countries, succeeded in turning intellectual property into a global trade issue by bringing it to the WTO, and which set minimum intellectual property standards. And before that, there were no common standards across the globe. Each country had a different standards. And it put big pharma's priorities at the center of trade policies. Now, nothing much have changed today as well. That expansionist agenda of IP still continues, but with newer tools and sharper tactics. Now, why I say so is that the 2025 Special 301 report and the National Trade Estimates report label public health safeguards like Section 3D, which Professor Das spoke about, and the refusal to grant data exclusivity as trade barriers, or having a deficiency in IP protection. Now, India is put on the watch list in the Special 301 report, which the US releases every year, which names and shames countries for having supposedly weak IP regimes. Especially they target countries which have pro-access IP laws. Since the last, India has been on that list since 2005, if I'm not wrong, and actually for rejecting weak patents or supporting laws that enable generic competition. Now, even under the reciprocal tariff, which after the Trump administration came in, the US have framed national IP laws as justifications for imposing tariffs, which kind of blurs the line between IP enforcement and trade retaliation. Now, when we talk about FTAs, we also need to consider all these factors where US has been trying to push their IP agenda. And if you see, US has historically, through free trade agreements, through bilateral trade deals, tried to systematically introduce TRIPS plus obligations, provisions that go well beyond international law that is required under the TRIPS agreement. Now, they do this country by country because I believe it's easier to get stricter rules via bilateral negotiations and then through consensus at the WTO. Next slide, please. Now, what are these TRIPS plus provisions that are being talked about in different free trade agreements? Let's kind of break this down. Uh, Next slide, please. Now, Professor Das again has spoke about India's patent law, specifically Section 3D, when it comes to patentability criteria. It lays down the standard or lays down criteria on which a particular patent should be granted for an invention. And Section 3D, when it comes to pharmaceuticals, sets a high bar for what qualifies as an invention and what should be patented. Now, it rightly excludes minor modifications, small changes to already existing known drugs, such as new users or new forms from being patented. Now, suppose say a salt form of a particular compound, if they filed for a new patent, it would be struck by Section 3D and it will not be granted a patent in India. But when it comes to TRIPS plus provisions in FTAs, they aim to lower that threshold, and US has been seeking to allow patenting for marginal or small modification, as I said earlier. Now, this is a classic case of evergreening, where companies file secondary patents or multiple patents to prolong the monopolies beyond the already allowed 20 years as per the TRIPS agreement and for the main patent. Now, the US, as I said, has been for a very long time demanding this, and this could result in high prices and block generic competition for a very long time, because once one particular patent ends in 20 years, then the next patent probably would kick in, which would extend the period of protection by 1 or 2 years, as the case may be. Now, if I can give an example of imatinib, which is a life-saving cancer drug, and India is also known for the Novartis case, which was litigated around this drug. Now, in the US, evergreening pushed its price almost to 1.6 lakhs rupees per month at that point of time. And India, when Novartis failed to get a secondary patent, generics brought down the price to cost to 9,000 rupees. So this is the impact that Section 3D has on life-saving drugs. Now, next slide, please. Now, as I mentioned earlier, under the TRIPS agreement, patents last for 20 years from the date of filing. But now FTAs often introduce patent term extensions, allowing corporations, pharmaceutical corporations, to claim extra years of monopoly. It could range between 1 to 5 years, primarily citing that they need to recoup the delays in regulatory approval or patent processing or patent examination on the grant of patent. Now, the term of patent, if I remember correctly, was debated during the TRIPS negotiation and was kept at 20 years to account for all sort of delays. Now, FTAs are seeking to extend this term beyond the 20-year period time. Now, if we take the example of imatinib again, though the main patent expired in 2013, the US granted a 2-year patent term extension, allowing Novartis to retain market control until 2015. Now, this when it comes to real term, it means a 2-year monopoly means Novartis could charge the price that they want. Now, these extensions don't reflect innovation, but in fact, they are what can be called as legal engineering tactics to keep prices high and block affordable medications. Now, moving on to the next slide, on next topic on data exclusivity. It is, again, one of the most stringent TRIPS plus provisions, which prevents drug regulators from using or relying on the data already submitted by originators to approve generic versions. So if there is already a drug dossier that has been submitted, generics could merely submit data to prove that their drug works similar to the originator drugs, and they could get approval for it. Now, what does data exclusivity do is they prevent generic versions to get regulatory approval even if there is no patent. So this means that generics cannot enter the market, not because of a patent, but because generics cannot get regulatory approval by not being allowed to compare with the data that is already present with the regulator. Now, this is, of course, a TRIPS plus requirement. This also becomes a bigger problem if the data exclusivity regime runs beyond the 20-year patent term, so which would extend the monopoly period beyond the 20-year term. Now, a classic example is that the US-Jordan FTA which introduced several TRIPS plus provisions like data exclusivity and patent term extension. And an Oxfam study basically said that the 79% of the medicines that were launched in Jordan has no generic competition. And it also found that the prices in Jordan were almost 800% higher than in Egypt, which had no such TRIPS plus provisions. Now, uh, moving on, if I can like club all this together into an example, Gargi, next slide, please. Now, if you take the example of bedaquiline, which some of you may be aware was a drug used to treat drug-resistant tuberculosis, which is now a lifeline for many patients and many people in national TV programs. Johnson and Johnson the originator company, the originator corporation had filed a patent on it, which the primary patent would have was in existence till July 2023. But they also sought secondary patents on new forms, that is the salt form of the drug, and also on pediatric and long-acting versions. And if these were granted, this could have extended its monopoly period beyond the original term of the patent, that is beyond 2023 July. Now, if there were patent term extension or data exclusivity regimes in India, they could have also pushed for that, which could have blocked generic entry for many years without actually making any new innovation. Now, but India very rightly rejected the secondary patents, and of course, it does not allow for patent term extension or data exclusivity. And as a result, generic entered the prices as soon as the secondary patent was rejected, and the prices dropped by more than 50%, not just in India, but it improved access globally because Johnson & Johnson did a non-enforcement commitment as well as soon as the secondary patent was rejected in India. Now, bedaquiline is a clear example why strong patent standards and rejection of TRIPS plus rules matter. Now, if we see the past negotiating history of India, India has shown global leadership by enacting public health friendly IP laws, by utilizing the policy space that India has in the TRIPS agreement by creating that pro public health friendly IP laws. But the US-India FTA could threaten to lock India into some that irreversible commitments, which Professor Das also spoke about earlier, that would have a direct impact on access to medicine. So India is currently negotiating FTAs with EU, has finalized one with UK, and now also considering US. Now, all pushing very similar IP demands. Now, I believe under pressure to secure a trade deal or to improve geopolitical ties, India must not rush to agree to harmful IP provisions and must continue to oppose all such provisions as it has been doing in the past as well. We have seen that the stake isn't abstract. It's actually about the lives of and the health of millions of people living across the globe. Generic medicines from India are used across developing countries, including, as I mentioned, treatment by us, including like treatment providers like MSF. Now, provisions like Section 3D have helped stop evergreening, has ensured that ensured that drug monopolies don't last forever. India's refusal to grant data exclusivity means generics can be approved without delay, and the moment the patent term is over, the generics can enter into the market. Now, weakening these protections would mean, of course, longer monopolies, higher prices, and very few options for people who rely on generic medicines from India. So in order to ensure that millions of people continue to access affordable generic medicines, India must definitely not trade away its ability to protect public health by diluting its very pro-access friendly IP laws through FTAs. Thank you very much, and I'm happy to take any questions later. Thanks a lot.
Thank you, Roshan. Thank you for this very engaging talk that you've given. And I think I'll just contextualize before we invite our next speaker. So as Professor Das pointed out, free trade agreements can have an impact of multilateralizing these TRIPS plus provisions, because like I said, that free trade agreements, existence of these free trade agreements, which may involve 2 or more WTO members, exist parallelly with the multilateral process. And whatever is agreed, like Roshan pointed out, a number of TRIPS plus provisions, it can be agreed between a smaller group of WTO members, not as part of the multilateral process, but as a bilateral or maybe involving more members process. And then that, if found in a number of agreements, can eventually be taken to the World Trade Organization, which can be very, very debilitating for access in the countries of the global south.